Thank you. Let's turn our attention to SB 641, which will assist consumers who suddenly find their wages garnished or their bank accounts emptied for a debt they either never heard of or, even worse, they don't owe. Currently, the only way for consumers to stop this injustice from continuing is to file a whole new lawsuit in equity. Not only can working class consumers not afford an attorney to file a lawsuit, but the money being taken from their paychecks is money they need right now to pay rent, buy groceries, and get through the week. SB 641's motion to set aside is not only much faster and less complicated than the lawsuit in equity for the consumer, but it is faster and less complicated for the courts. As the analysis notes, costs are minimal and absorbable to the Judicial Council, and I urge an aye vote.
Thank you so much.
Thank you, Mr. Chair and members of the committee. Jessica Bartholow with the Western Center on Law and Poverty. Many of our legal aid services centers throughout the state are seeing more and more people who are victims of consumer issues and consumer debt that is not their own. One of those is the sponsor of this bill, the East Bay Community Law Center, that has brought forward the bill with the senator. The purpose of this bill is to simply open up the doors of justice a little bit wider for people who are garnished or have their bank accounts levied because of a debt charged to them that they don't owe. It's signed with very little state cost, and we appreciate your aye vote. Thank you.
Move the bill. We have a motion by Quirk, a second by Wood. Please continue. Any other witnesses?
Noah Paramo, representing California Rural Legal Assistance Foundation, in strong support. Thank you.
Thank you so much. Individuals from the public in support?
Deputy Attorney General Matt Campbell, on behalf of Attorney General Kamala Harris, in support of the bill.
Thank you so much. Any other individuals in support? Witnesses in opposition, come to the desk.
Tim Lynch on behalf of DBA International, the trade association representing the debt buying industry. We still have significant policy concerns with the bill, but relative to the cost, as noted on the previous bill, the judiciary has lost $1 billion over the last several years. The most conservative estimate on this bill says there will be at least a tripling of the cases by taking the 2-year current window in law and tripling that to 6. In addition, the bill allows cases going back to 2010, so it has this retroactive application that allows cases that are otherwise time barred from being re-entered into the courts. And the bill created new unlimited, undefined, time unlimited claims to be made under mistaken and stolen identity that we think need to be defined and reined in some regards. Perhaps the most disturbing thing about this bill is we'll actually have no idea what the fiscal impacts are. This data is not tracked currently by the judiciary, so we can get some sort of sense based on the timelines in the bill, but in 3 years or 5 years from now, we'll have no idea what the actual impact was. So for those reasons, we're opposed.
Thank you so much. Individuals from the public in opposition?
Good morning, Mr. Chair and members. Tracy Stevens, representing the California Association of Collectors, and we're also opposed.
Good morning. Nathan Searles of PRA Group and its 7 offices and 200 employees, and we are also opposed.
Thank you so much.
Mr. Chair, Mike Belote on behalf of the California Creditors Bar Association, opposed for the reasons already stated.
Thank you. Department of Finance?
We have a neutral position on this bill, no fiscal impact.
Thank you so much. Questions or comments from the committee members? Seeing none, Ms. Rakowski, would you like to close?
I urge an aye vote.
Thank you so much. We have a motion by Quirk, second by Wood. This bill is out on a B roll call, daily not voting.
Thank you, Daly.
Thank you so much, Senator.
Thank you.
Senator Bates. Senator Bates, you have 3 bills on suspense.
Yes, Chairman Gomez, and I am going to waive on 2. I wish to present on SB 722. Understanding it is a candidate for suspense, it certainly embodies a very significant and serious issue that I think needs to be addressed.
Thank you, Senator. Please continue.
Good morning, Mr. Chair and members. Senate Bill 722 would authorize a felony penalty of up to 3 years for child molesters and rapists who willfully remove or disable a GPS tracking device. We did take amendments in the Senate to tighten SB 722, ensuring that it would only apply to the dangerous supervised persons as distinguished from other supervised persons who, without this intent, nevertheless allow or cause their GPS to fail. As your committee analysis noted, I understand additional time behind bars will cost California more money, but I do believe we can all agree on the importance of keeping the public safe and ensuring these very dangerous individuals who intentionally evade supervision with the purpose of causing further harm should serve their time and not just be back on the streets with a GPS tracking device that they feel is not a deterrent since they do remove them. A recent killing spree in Orange County left 4 innocent women dead, and the murders were later linked to 2 high-risk convicted sex offenders who at the time were on GPS supervision. After more of the investigation developed, we found out that not just once but twice these men cut off their GPS tracking devices and left California. Existing law does not provide the tools to keep these offenders locked up. Ultimately, the cost to lock up offenders for a long period of time is minor in relation to the lives that we've already lost due to the existing statute and the lack of tools for law enforcement to take appropriate action. The families of these victims are paying the highest price in the death of their loved ones. Therefore, it is imperative that criminals with these intents are held accountable, and SB S22 seeks to start that process today. It deliberately focuses on the most serious, heinous sex crimes by limiting its application to the offenses deemed most egregious by this legislature when it approved the one-strike rape law. The premise is behind one-strike rape is that one victim is enough, and these specific offenses are rape, spousal rape, sexual penetration, lewd or lascivious acts against children, sodomy, oral copulation, and continuous sexual abuse of a child. It's not comforting to the families of these victims in Orange County when twice these offenders were apprehended and twice cut off their devices, and yet they still managed to commit 4 murders before being arrested. I think it's important to show the victims' families that this legislature is serious about these crimes and we intend to do something about it. I'm pleased to have with me today as witnesses in support Orange County Assistant Sheriff Linda Salarza and San Diego County Deputy District Attorney Rachel Solub to testify in support.
Thank you so much. This bill is on suspense. Please keep your comments to 1 minute apiece. Thank you so much.
Good morning. I'm Deputy District Attorney Rachel Solov here on behalf of San Diego County DA Bonnie Dumanis. Offenders cutting off their GPS devices is a significant public safety issue that extends far beyond the tragic homicides in Orange County. This is a regular occurrence amongst a very dangerous criminal population. These offenders know there's virtually no penalty for noncompliance with this condition. They talk, they research, they consult with criminal defense attorneys. They are sophisticated. I can tell you about cases I have personally handled where not only a parolee has cut off their GPS, but they have expressly stated they know we can't do anything about it. In one of those cases, the parolee actually wrapped the GPS up in bubble wrap and sent it back to parole with a letter saying, I know you can't do anything to me. The 180-day penalty that they get, which is actually only 90 days, is inconsequential. They do not care about doing 90 days back in custody. GPS is a threat management tool. The only way it is effective is if there's a significant penalty for noncompliance. This is money very well spent. The cost of not supporting this bill is greater. What is the cost of a human life in the criminal justice
30
system?
seconds.
According to a presentation at a FBI violent crime seminar I taught at last week, the cost of a murder case to a local jurisdiction is $3 to $7 million. Add to that the cost to the state to now house that prisoner for a life term. Consider also the cost to law enforcement to track these offenders down when they have
Please wrap
spawned,
up.
and then to prosecute them for the crimes they committed while on the run. In my humble opinion, your failure to move this bill for fiscal reasons would have a direct negative impact on public safety. Thank you.
Thank you so much. Next witness.
Thank you. Good morning. I am Assistant Sheriff Linda Solorza, and I'm pleased today to represent Orange County Sheriff Sandra Hutchins in support of SB 722. The establishment of a felony penalty for convicted sex offenders who willfully remove or disable their GPS tracking device. Removal of this device by a convicted sex offender is serious. As a 29-year veteran of law enforcement, I can tell you that it is my experience that offenders generally remove these devices when they have nefarious intent. To me, that means doing something they're about to do something they shouldn't, or they're somewhere they shouldn't be. A felony penalty for device removal may prevent serious crimes from occurring. We know it would have in Orange County. This legislation is well worth the financial cost it may incur. I encourage you to view the cost as a prudent investment that will further enhance the level of public safety in our state. It would also provide some level of security to the victims of these felons. While it must be challenging enough to know that these assailants have been released from prison and are subject to GPS tracking, it must also cause a great deal of angst to know that it is not considered a felony to remove the GPS tracker. And in my opinion, the deterrent imposed by this law would have a significant value in two areas. One, due to the severity of the penalty for removing the GPS tracker, it should give a convicted criminal pause before disabling or removing device. And two, it would provide an additional level of protection for those already victimized.
30 seconds.
And equally as important for those who would be prey. I ask you today to join with organizations such as the California State Association, Sheriff's Association, the Peace Officers Research Association, and the California District Attorneys Association in voting in favor of this bill. Thank you.
Thank you so much.
John Lovell on behalf of the Association for Los Angeles Deputy Sheriffs, California Association of Code Enforcement Officers, California College and University Police Chiefs Association, California Narcotic Officers Association, California Police Chiefs Association, Los Angeles Police Protective League, and Riverside Sheriffs Association, all in support.
Thank you so much. Individuals from the public in support, name, organization, and position, please.
Sean Hoffman with the California District Attorneys Association, also in support.
Mr. Chair, members, Aaron McGuire on behalf of the California State Sheriff's Association in support.
Nicole Wertelman on behalf of the Orange County Board of Supervisors in support.
Matthew Seiberling on behalf of the Los Angeles Probation Officers Union, ASME Local 685 in support. Thanks.
Thank you. Thank you so much. Department of Finance. Oops, sorry about that. Witnesses in opposition. I was getting ahead of myself.
Micah Doctoroff on behalf of the ACLU of California here in opposition to SB 722. We do not believe that this bill will serve the purpose that it's intended to serve. We think that it will increase costs significantly without proven efficacy. We think that there are other laws in place that already address this issue, and there's no need to spend additional dollars on a measure that is not proven to work. Thank you.
Thank you so much. Individuals from the public in opposition, seeing none, Department of Finance.
We are opposed to this bill because it could increase the state prison population, which impacts the state's ability to comply with the federal court's order to reduce prison overcrowding to 137% of design capacity. To the extent the measure increases state prison population, additional bed capacity, and an annual contract bed cost of approximately $27,000, or population reduction measures may be needed to comply with a court-imposed cap.
Thank you so much. Mr. Wagner.
Thank you, and I want to thank the Senator for bringing this bill forward. I know it's a suspense candidate, so it won't take long, but I had a GPS bill working on a different angle or a different aspect of this problem, and so I've had a chance to dig into this. One of the mothers of one of the women killed in the crime spree that prompted this, I can't quote her, I will paraphrase, the heartfelt why. Why they have these bracelets on, we're supposed to track them, we're not tracking them, we don't penalize them. Why do we let this happen and only deal with it when after somebody's had to bury a child? I don't have a good answer for why we let it happen. I think this bill is a great answer to, hopefully, so the next parent won't have to ask that question. Will it increase costs? I think that's probably not accurate, and I'll tell you why. But even if it does, we've got an obligation to pay to keep our citizens safe. But putting these penalties on, and why this bill ought to come off suspense with 100% support from this panel, is why we may increase the cost of incarcerating a couple of people. We will say to so many more, you aren't allowed to do this, and we will come after you if you do. We will have a lot fewer examples of people actually taking the steps of cutting off the bracelets and mailing them to the DA and saying, I dare you to do something about it. Those people will stay monitored, and they won't be back in the system. They won't be allowed to kill. They won't be costing us $3 million, that's the low end, for one murder. We have 4 in Orange County. Let's take the low end. That's $12 million the county had to spend. It wouldn't spend. So let's not be penny wise and pound foolish. Excuse me. When this comes off suspense, it ought to come off with unanimous support. Go to the governor and let's answer the last parent by saying we recognize your pain and are doing something about it so nobody else suffers the same way. We owe it, and this is an awesome bill, and thank you, Senator, for bringing it.
Thank you. Thank you, Mr. Wagner. Any other questions or comments from the committee members? Seeing none, Ms. Bates, would you like to close? This bill is on suspense, and we will take it up in due time.
Thank you, Chairman. I just respectfully ask that it receive your support to move from suspense for a full discussion on the Assembly floor. I just want to see that these guys are not going to be able to game the system, and in particular put our children at risk. I think we all know the predatory nature of many of them, and that really needs to be reined in. So I thank you for your time.
Thank you, Senator. Mr. Huff. Mr. Huff, you have 2 bills, one on consent, SB 416, and SB 597 is a due pass recommendation. How would you like to proceed?
Well, I would like to discuss SB 597. It's your pleasure.
Thank you. Please begin.
Thank you, Mr. Chairman and members.
Move the bill.
A quarter century ago, there was a discussion that was gripping the state of California and the nation about vouchers for schools. And one of the creative alternatives to that emerged out of this legislature was a district of choice program that allowed a district to declare itself a district of choice, to open up its borders, and the schools that kids would come from couldn't say no, as they do through interdistrict transfers. So over the years, this has serviced thousands of students. It has proved to be a way for parents to choose what's best for their child, whether it be safety, close to a job, or because of other matters, academic excellence. And it's proved that schools tend to compete in a way that's healthy to improve academic programs. So as we move into an era that we have close to 50% of our schools in declining enrollment, this tool is an important tool to make sure that the best schools are serving our students. The last reauthorization of the District of Choice, and by the way, it's been authored and extended in both bipartisan manner. I've carried the last couple extensions. The last one was joint authored with Democrat. We put into effect a report that was supposed to be to us in 2014 by the legislative analysts. That has failed to materialize. And so this is a modest extension to give time for that report to come in. And in the meantime, this will expire next summer, and it'll put thousands of students in limbo. They won't know where they'll be going to school. So until we get the report, this is a critical extension. And then with the legislative analyst report, we hope to be able to have a more comprehensive look at how is this impacting our educational system, in particular the students that have been availing themselves to it. So the analysis accurately reflects that the small extension has no significant state costs, and I would ask for your aye vote.
Thank you so much. Witnesses in support.
Good morning. Michelle McKay Underwood on behalf of the Alexander Valley Union School District and the Pine Ridge Elementary School District, both participating in the District of Choice program. We think it makes a lot of sense for our districts, for the students and their parents, with very minimal cost to the state, and for those reasons we respectfully ask for your aye vote.
Thank you so much.
Mr. Chair, members, Jeff Frost, representing the Riverside Unified School District. We are in strong support. I just wanted to note, as Senator Huff had indicated, the data that is being collected is statewide data, but the dispute is really about 2 school districts. And I think that will be easily resolved when the data is available, which is why a 1-year extension makes sense. Thank you.
Thank you so much.
Jennifer Wada on behalf of Ed Voice in support.
That's great. Any individuals from the public in support?
Leangela Reed on behalf of the Small School Districts Association in support.
Thank you so much. Witnesses in opposition, individuals from the public in opposition, Department of Finance.
We have a neutral position on this bill, no overall state fiscal impact.
Great. Questions or comments from the committee members? Seeing none. It's good to see the Riverside Unified School District here, since I was a graduate from the school district, so it's good to see that they're here. Mr. Huff, would you like to close?
I ask for your aye vote.
Thank you. We have a motion by Chang, a second by Bigelow, and this bill is out on an A roll call.
Thank you.
Thank you.